So welcome to another one of our webinars. My name's James from Community Legal Centres Queensland. Can I begin the session by acknowledging the traditional owners? Amber and Laura, our presenters, are in Brisbane at the moment, actually at the Community Legal Centres Queensland office. And so we acknowledge the Yagara people as the traditional custodians of the land they're on. I'm dialing in from the National Access to Justice Conference in Adelaide, so I acknowledge the Kaurna people as the traditional owners of this land, but pay respects to elders past and present across the country, because we do have people tuning in mainly from Queensland but from other parts of the country as well, and we are all living and working on Aboriginal and Torres Strait Islander land. Today's session is looking at how we can work with Legal Aid Queensland, which is an incredibly important partnership and relationship for those of us working in community legal centres across the state. And indeed across the country, community legal centres work closely with legal aid commissions in a really collaborative and client-focused way, which is incredibly important to get the outcomes we're looking for. A couple of housekeeping things. We'll email around copies of the PowerPoint presentation later on, either today or tomorrow. So no need to furiously scribble notes, because you'll get a copy of Amber and Laura's presentations. Also having to have a recording available as long as the technology lets us do that. So fingers crossed that works out. In terms of asking questions, we might ask you to hold on until the end of the session. The webinar technology isn't great for kind of really interactive Q&A style stuff. So if you can hold your questions over, there are two ways that you can ask questions. One is to press that button that looks like a hand. We'll unmute your microphone. You'll be able to ask a question that way. You can also type a question into the questions box. If you do have a burning issue, feel free to send it through, but as I said, our preference is to hold over the session until the end of the session. Two kind of discrete topics that we're looking at. One, whether a client who comes into a CLC is eligible for legal aid funding, and Amber Buckland will be presenting that. And the second half of the presentation, if you like, is in particular how we might prepare clients for appearing in court, given that there's not a lot of representation in courts done by community legal centres relevant to legal aid. So making sure that those linkages work really well. It's really great to have Laura Rouse from Legal Aid presenting on that. So I might hand over now to Amber. Thank you, Amber. Thank you, Laura, for the presentation, which I know is going to blow everyone's socks off. And thanks everyone for tuning in this morning.
I'm not sure about blowing everyone's socks off. This is Amber Buckland here, and I'm currently the Assistant Director of Grants at Legal Aid Queensland. I've been given a very dry topic, and my apologies for those who may have attended these types of things before. I guess eligibility for legal aid is one of those things that we absolutely need to keep rehashing and reviewing, because we know that we have plenty of staff who turn over, and there sometimes can be little new tidbits of information, I guess, that come through as changes are made. So I do apologise, it's a very dry presentation. I just couldn't see my way clear of a comedic role when we're talking about these things. But certainly the question that's been posed is a client of a CLC eligible for legal aid funding? And I guess it's really important to look at a client in both ways, in that it may be that a client can get legal aid funding both by applying and being allocated a preferred supplier, but there's also some grants of aid which are available for CLCs, and I'll cover those today. So I'll just run through the basics, and then we can move on to those specific CLC grants of aid at the end. In terms of your client, it should be said that all clients can apply for legal aid, and people are encouraged to have them apply, but certainly they need to be very aware of who is eligible, and that we have some guidelines in terms of the Legal Aid Act and also our funding bodies, the Commonwealth and state governments, who provide us with some guidelines in terms of what we are to fund and who has priority. So in all of this, it's really important to remember that if you're not sure that Legal Aid Queensland has got a call centre, and that the call centre operators are highly trained people. They go through about 4 weeks of training and give information and legal and advice in relation to legal aid funding. Oh, James, unfortunately your phone's ringing.
That's right. I'm sure someone else in the office will pick it up. Won't be long.
Okay. Thank you. If you're concerned or you need some more information, our call centre operators are very willing and able to help in relation to both the types of things that we fund, but also providing legal information and booking them in for legal advice if that needs to be done. We have extraordinary demand for our services, and in particular at the moment our criminal law services are very much stretched. As you're probably aware, in Queensland about 1,100 police were employed, and what that obviously generated was a significant increase in spend in all of the criminal law facets of the legal system, including legal aid. So we are really feeling the pressure at the moment, and so the use of strict criteria is very important in allowing us to fund those who are least able to afford a lawyer and the most vulnerable in the system. One of the ways that we do that is by using a means test, and the means test is a financial eligibility assessment, and it ultimately looks at income and assets and things like the number of people that a person will support. It also takes into account the income and assets of anyone who helps the family. Now that particular, the helping of the family is becoming more and more obvious as there's more and more people coming into the workforce in terms of couples. It also includes people like mothers who help their sons, those types of things. So we do take those types of things into account. When you apply for legal aid, there's a very large legal aid application, the form I like to call it, and you will have to wade your way through that form and provide as much information as you can in it. And part of the requirements, in particular in relation to the means test, that you need to tell us about all of the money that clients regularly receive, including salaries and wages and income that they get from investments, shares, etc., and even lump sum payments that they've received in the past, and an assessment will be made of that income. People who rely on Centrelink payments are usually eligible for aid, but sometimes the assets part of the test can be a difficulty for them. So we'll move on to the assets, and essentially the types of assets that Legal Aid are looking for are real estate, cash, shares, debentures, caravans, jewellery, those types of things which can have significant value placed on them. And there are some exclusions to that, and I've put a link on the presentation as to what those exclusions are. The means test uses essentially a sliding scale when we're looking at whether or not we could fund someone if they pay a contribution. So some people are assessed for legal aid funding and they will absolutely meet the means test and will simply be granted a grant of legal aid. But then there are others who would not generally meet that, but because we have this sliding scale of initial contribution, if they pay that amount which is assessed as a contribution towards their legal costs, then they will be in a position to receive that grant. It's an expectation in terms of the contribution that the contribution is paid before any work takes place, and we've found that the preferred suppliers also work on that basis as well. Otherwise, what will happen in terms of their grants of aid is that the contribution will actually be deducted from the money that they are paid for the services that they provide. Sometimes people don't meet our means test guidelines, and we have what is called a special circumstances test. Now, in order to qualify for that, essentially there needs to be a number of vulnerabilities and those types of things, but certainly if you have a client who has a number of vulnerabilities, but for instance they have a little bit of extra cash, then it is well worth applying for the grant of aid, and what will happen in those types of circumstances is that that matter will actually be referred to someone with a higher delegation within legal aid to assess whether or not we can not apply those very strict means test guidelines and allow them the special consideration to move forward. What we've found in that type of space is the examples of the types of people that we tend to fund in there are people who are under the care of the public trustee and also the adult guardian, and they, as a result of those people managing their affairs, have accrued a little bit of money, which ultimately is usually earmarked for their living expenses and for medical things and that sort of thing. They usually have significant impairments, and in those types of matters we would seriously consider whether we can dispense with the strict guidelines of the means test. The next part of applying for legal aid is that there is also a merit test, and the merit test is a case-by-case assessment of the legal and factual merits of a case, and if it is more likely to succeed or fail if it goes to court. It also has another limb to it, which is if a sensible person would risk their money to take the case to court, and if the benefit to the applicant will receive from having a lawyer justifies spending the limited public funds on their particular matter. The first one in terms of success or failure at court is fairly self-explanatory, as is the second point. I guess the third point is one where the special circumstances test in particular in relation to assets comes in that sometimes it is the case that a person may not be able to understand the proceedings that are happening, or they need the assistance of a lawyer because of their multiple vulnerabilities. And in that case, it may be that they qualify for the special circumstances. So there's those tests in relation to means and merit, and then legal aid also needs to apply their guidelines to matters once those assessments are made. The guidelines that legal aid are required to use are set by our funding bodies, our Commonwealth and state governments, and they list out essentially the matters which they require us, first of all, to make sure that we allocate funding for. And you'll see that there's a list there which encompasses civil law matters, criminal law and family law matters. This is, I guess, a way of setting our priorities and trying to figure out what are the matters that are required to be funded in terms of the limited funding that we have. So when you're dealing with the grants officer, there are a number of things which come to mind for them. So first of all, there's the means test. Then there's the merit test. Then there is the question, is there a grant of aid for this which fits our guidelines? And then as part of that, they also use what is called the Legal Aid Grants Handbook in order to interpret the guidelines where there might be some doubt. So I absolutely commend to you to look on the Legal Aid Queensland website and to find the Legal Aid Grants Handbook, because usually the answer will be in there if you're unsure about things in any event. And you can be assured that that is actually the place where our grants officers also look to when they're concerned about a decision. The next thing that the grants officers need to look at is what documents are needed to support their decision. And there is an absolute requirement for financial information in evidence form to be provided to legal aid. A copy of a healthcare card or a pension card, copies of pay slips. My presentation says the past 4 weeks, but that has recently changed to the last 3 months. And the reason for that is that, I'm sorry, I'll take that back. Bank statements are for the last 3 months and pay slips are for the last 4 weeks. I'm getting myself confused here. And also any copies of tax returns and assessments that are available, particularly in relation to business owners, and any court or legal documents about the problem. So I should talk about the bank statements for the last 3 months. There's been a real drive for compliance with that particular requirement. There has been audit across the state in relation to that issue, and it really has been something which our board has been driving in terms of making sure that that evidence is held on file. So if we're going to apply for legal aid, it's really important that you do obtain those things for your clients, from your clients. It may be that you can provide them, say for instance, with access to a computer so that they can print their bank statements off, or assist them in terms of directing them on how to get their bank statements. But essentially without that information, the grants officer can't go any further until that information is received, and it will simply delay the process. Just in terms of our preference for how applications are received, certainly it is the case that we always recommend that clients seek some legal advice. We find that legal advisors are generally able to grab the legal aid form and, for instance, fill in the part which says, please explain your legal problem. It very much assists us to have that filled out in a way which is helpful, rather than, for instance, in a family law matter saying, I want custody of my children, and that's essentially the only information we get. That, for instance, is just something that we couldn't proceed with a grant of aid on without some further information and delay in relation to supporting a decision that we make. The next step that they need to take is to complete the legal aid application form. It's really important that the client signs the legal aid application form, and that can be obtained from our offices, and we also have a website copy which can be printed down. The website copy has just been improved, and once we run out of our current print run, we'll get some improved printed forms as well. But it includes things like amendments which track the IOMS number, which is the prisoner number, so that we can ensure that we can send mail, etc., to prisoners, and streamlines processes and gets rid of delays. We assess about 90% of our applications within 5 days, and if there's been no response 14 days after lodging the application, you should contact us, and you should contact us through our call centre 1300 number. Sometimes we need to ask for more information, and that may delay any decision that's made. If there is a refusal of a grant of aid, then certainly there are options available in terms of requesting for a review of the decision, and then we also have, so that's done internally, and then there is also an independent external review officer who can also review decisions which are made. Our external review officers, or EROs, are people who are not employed by legal aid, who reconsider decisions that are made and apply their expertise in the area in order to consider those decisions. There are some specific grants of aid which are available to CLCs, and I think it's really important that you guys know that they're available so that you can access them. They're processed in the same way as all of the other preferred supplier and client applications are processed. If there is a grant of legal assistance approved, then It may be referred back to the Community Legal Centre, and there's some requirements there on the slide in relation to what's required in order to do that. You should note, however, that the grant is only in relation to disbursements, and disbursements include council fees. Otherwise, if it's the case that the Community Legal Centre can't take the grant of aid for some reason, then generally it'll be referred to an in-house solicitor or a preferred supplier on the panel. We also have the Family Dispute Resolution Conferencing Program within our family law space, which allows for CLCs to represent clients at legal aid dispute resolution conferences. Council grants are not available within that space, but it's helpful for you to apply for those, because it then allows legal aid to provide the grant and then track that client particularly through, and if issues aren't finalised at the conference, then that client can then apply for aid in the usual way, and it streamlines that process. In relation to court proceedings for CLCs, legal aid can only be granted where aid is required for counsel and the briefing of counsel. Essentially what that means is that a client who would receive this type of grant of aid would, if they had applied for legal aid in the usual way and had received a substantive grant of aid for the issue, would be eligible then for the CLC style grant of aid, which is for the council. So it's very important that you understand that in relation to the grants, that disbursements such as things like reports can only be issued in situations where the client would have qualified for a grant of aid but for the fact that they were at the CLC. You can see there the types of disbursements that can be claimed in relation to the grants of aid, and certainly that I know can be very helpful. Okay, just bear with me. I've just got a little display there of the manner in which you can apply for grants for a conference or council or disbursements in our e-lodgement on Grants Online tool, just so that you can see exactly how you can do that. I guess just to end, in terms of completing an application for legal aid, information is the key. Grants officers have a lot to consider. Means, merit, does it fit our guidelines, is there an available grant of aid, is there sufficient information to support the decision that's been made. And in order for them to be able to do that, it is really imperative that the information in the legal aid application can be as fulsome as possible. Don't be afraid to attach further information if you need to, particularly in relation to family law matters. If you can access a QP9, that's really helpful in that a grant generally can't be obtained until a QP9 is on the file, because that's evidence of the particular charges that have been laid against the client. In our experience, if we fail to get the QP9s, our clients are notoriously unable to report accurately what their charges are, and that can pose great difficulty and confusion in terms of what they're actually eligible for or which court they're in, those types of things. So that accuracy is very important. But familiarise yourself with the Grants Handbook. I really do. As a practicing solicitor myself, I've found it very helpful because it really does guide you in the right direction as to what types of things that you might want to apply for or didn't know you could apply for. And attach everything that you can. If there are checklists available, please checklist them. Your opinion in relation to these things is very important. But if you can't checklist it, don't automatically assume that a grant won't be given. It may be that some additional information might be why, for instance, we can apply the special circumstances test or be able to assess it in a different way. Just a little note also that if you've got any non-English speaking clients, that in order to have the application process assessed, please encourage your clients to use the TIS interpreters, and that can be done through Legal Aid Queensland and our information officers as well. I've just got some referrals information and that sort of thing, just so that you know exactly where you can send your inquiries. And that is the end of my presentation.
Amber, it's James. Just while you're handing up over to Laura, I might invite people to ask questions about your part of the presentation now. We'll have some time at the end, as I said. But if anyone's got any questions for Amber about that process of applying for or receiving grants, reminder that there are a couple of ways that you can ask questions. You can type a question into the questions box when you go to Webinar Control Panel, or you can press that button that looks a little bit like a hand, and we'll see a hand go up and we can unmute your microphone. It looks like people are holding back Amber until the end of the presentation, which is fine. So I might invite Laura now to talk about referring clients who are.
Thanks, James. I'm just having some trouble inviting the computer to join in with us. We're just going to get some help. The little mouse cursor is on the second screen, and I can't bring it down to the screen that my PowerPoint's on.
You right to go there, Laura?
No, we're just getting some help though. Yeah, I'm on my way. It may not be very helpful, but let's see how we go. Looking less helpful by the minute, but you know, just bear with me. Oh, there you go. Hello world. This is me being inadequate with technology. James, just while that's happening, I also would encourage everyone to make contact with their grants officer if they're concerned about issues, and or give me a call if you're worried about something or you need to escalate something a little higher. We're always very willing to have a chat about things and to see what we can do in the circumstances. Sometimes things just don't fit boxes, and we know that. So as best as we can, we will definitely try to help you out where we can. I know this is not great. James, do you have any IT support here? We've got double screens, the cursor is not moving onto the screen that has the PowerPoint. Can you undo the double screen? Have I still got you? Are you still there, James?
I am, yes. You right to go?
Right. I think so.
All right. Thanks for bearing with us there, folks. Over to you, Laura.
Okay. My name's Laura. I work in the criminal practice at Legal Aid Queensland in the Brisbane office. I'm a principal lawyer there, and I look after the team that's called Solicitor Advocates. And basically what my team does is focuses on advocacy in the Magistrates Court. We do take matters that go through to the High Court as well, but our focus is on the Magistrates Court. So the people in my team duty lawyer all of the Brisbane courts that have duty lawyers, and we look after a couple of regions as well. I am going to do a talk that refers to duty lawyer service around Queensland, but many of you will have better knowledge of the regions that you're in than I do. Okay, so the first thing I thought I'd talk about is whether there was a duty lawyer service available. So there may or may not be a service available depending on the day of the week that your client's going to court in a particular region, or even in Brisbane, which court they're going to. So in general, there's no duty lawyer service available for people that are proceeding to summary trial on the particular day that you're talking to them about, or full hand-ups, lengthy pleas of guilty, or traffic court. So the traffic court matters, you're probably all aware of, part of the guidelines about what the government funds and what the government doesn't fund. And effectively, if the traffic court matters where the magistrates follow a fairly standard sentencing guideline in terms of what fine's going to apply and those sorts of things, then there's really no point in having a duty lawyer service there anyway. Effectively, legal representation in relation to those matters does not create a better outcome. But if the person is at risk of imprisonment in relation to multiple unlicensed or disqualified, then that can become available. In Brisbane itself, any of the CLCs who are telling people about coming to traffic court in Brisbane, there is no duty lawyer service available at the traffic court in Brisbane because it's a separate court on a separate floor. So it would be a matter of them either applying for legal aid if they're eligible because they're on multiple disqualifieds and therefore at risk of jail, or asking their matter to be transferred out of traffic court and into the duty lawyer court. Sometimes what that will trigger is a magistrate alerting duty lawyers on other floors that they have one of those matters and us going up to traffic court. But I just raised that so that you know that if you're sending your clients off to traffic court, even if they are at risk of jail, we simply won't be there as duty lawyers until we're alerted to that particular matter. We don't get involved in the other matters that I spoke about, the summary trials, the full hand-ups or the lengthy pleas, because it would be simply negligent for us to do so. The duty lawyer time, of course, is a very restricted amount of time we get to spend with the clients. We meet them there. We learn about all of their legal problems and their personal circumstances there. So if they have briefs of evidence, need advice, need conducting of trials, or even the full hand-ups where they need to know whether they can cross-examine and all those sorts of things, it simply isn't enough time. And in general, in terms of lengthy pleas of guilty, which in Brisbane Magistrates Court are defined as sentences of over half an hour, generally your 45-minute to an hour sorts of matters, it's generally expected in those sorts of matters that you're going to have comparative sentences, you're going to know that client's antecedents inside out, and it's simply not something that a duty lawyer can get involved in. In general, those are the matters, though, that would get a grant of aid. So we encourage clients before they get their matters to lengthy plea court to have applied for aid. I've put a note there that in regional courts, duty lawyers may be only available on certain days. We do have a list at our office in terms of all courts across Queensland and what days the duty lawyers are available and those sorts of things. And you're probably all aware in your own particular areas what days different courts have different duty lawyer services. And then I've also noted that in Brisbane, duty lawyers are only available in certain courts. So, of course, we have 2 court buildings and a number of different things going on in those courts. In general, we duty lawyer in Brisbane the arrest court, which includes your in custody court and the on bail courts. And then in George Street, we duty lawyer most of the specialist lists. So we do the committal call over, on a Monday. On Tuesday we do breaches call over. On Wednesday we do summary call over. On Thursday we do the mental health call over and the case managed list. And on Friday we do Commonwealth call over. So whereas we have separate lists in Brisbane that we can focus on, in the regions they're quite often all put into one day, and depending on the list, depending on the attitudes of the different magistrates controlling those lists, will depend on how much assistance we can give at those call overs, and I'm going to come to talk about that a little bit more. So if you're referring a client to see a duty lawyer, either because it's their first mention and they're going to be applying for legal aid, or because they're simply not eligible for aid and they're going to be using the duty lawyer service to assist them through the process, if you want to, you can send us a memo indicating that you've seen the client and they'll be attending, and we can look out for them and we can read whatever it is that you've told us about them before we meet them. Unless you're prepared to go on record as acting, the client must attend court. Every now and again we do get a memo from either a preferred supplier or one of the CLCs asking us to appear for somebody who isn't there, but then at the same time you're not asking to go on record, and that's just simply not possible. The only way out of the bail act for the client not to be there in person is that their lawyer is going on record as acting for them and seeking to have their appearance excused. So that's something to be live to, even though you can tell us that you're assisting them. And if you're not technically acting on their court matters, then they must be there. They must always attend for any notice to appear or a mention appearance required. So even in circumstances where they do have ongoing representation, just be aware whether it's their first mention or not, and they'll need to be there to enter into bail, or whether they've had some problems in the past and a magistrate's advised them it's a mention appearance required regardless. And that's something that's tricky for everyone in terms of the first appearance after they do have a grant of aid. I personally always advise my clients that it's always a good idea for them to attend that first mention after they've got legal aid alongside me, in case it's a mention appearance required, unless they're confident that it's not. Another good thing for the clients to know before they arrive, if you've advised them to come and see a duty lawyer, is that there is going to be a delay. So if they are wanting to see a duty lawyer, that can be anywhere from a 1 hour delay to all day, depending on which court they're turning up and what the numbers are. For example, the summary call over on a Wednesday is our biggest day. It does go into the afternoon, which means that while some clients we get seen in the morning, other clients aren't appearing until the afternoon. The court has designed the numbers on the list. Yesterday was 247 with 168 people not with a grant of aid. So that court is designed with those numbers to go into the afternoon. It's not expected that it's going to finish at 11 o'clock or that sort of thing. That's a court list that is extremely frustrating to clients, because their view is, I've been here since 9 o'clock and my matter's going to take 10 minutes. Why am I appearing at 4 o'clock? So it's a list that we try and manage their expectations from the moment they arrive about how long they're going to be there for. I've also noted here that the duty lawyer may or may not be able to finalise the matter on that day. That's something else that's useful for them to know if you are referring them to us. It really just depends which list they've come to, what day it is, as to whether we can finalise it. So for example, if it is their first court date and it's a matter that we can resolve in less than 15 minutes, we're generally allowed to do those pleas there and then. It's going to depend on what region you're in as to what the rules are, but in Brisbane, for example, in Roma Street arrest courts, we can only do pleas that are going to take up to 15 minutes without tendering any material. If we need to tender any documents and it's going to push the matter over 15 minutes, we need to go to the George Street building to court 18 for sentence if it's around about a 15 to 30 minute plea. Anything longer than 30 minutes is designated as a lengthy plea. Goes off to lengthy plea list, and at the moment the next available dates are in June. So it's useful for the clients to know that that if they've got a matter that has some length to it, or there's a number of charges that give it some length, that they're not going to be able to finalise it that day, but they can come and see us to get some advice as to how long it might take them. It's not possible to brief a duty lawyer, and whilst we do appreciate any information that preferred suppliers, CLCs, anybody referring to the duty lawyer service can give us, it's really a waste of your time to send us any instructions and those sorts of things, making it a bit like a brief to a duty lawyer. It would be fantastic if we could take briefs. It would reduce the amount of work we have to do, but we can't do that. We need to take their instructions ourselves. We're still going to need to read that QP9 to them. We're still going to need to explain all their options to them, take our own instructions that they do want to plead guilty or they want to plead not guilty or want to make bail applications and those sorts of things. So the next slide I've done is what you can help them with and what they could come along with. So preparing documents and evidence for court. One of the things that it's good for you to assist them with if they are hoping to finalise their matter as soon as possible is to be coming to court with any references or letters of support from agencies they're linked into. Sometimes it's the difference between a fine and a community-based order like probation as to whether a client needs supervision, and that can be proven by the letters of support from agencies. It can also be the difference between a suspended sentence and parole in terms of whether the court thinks that they should be on a supervised order because they need to be linked in to get some assistance. And often if we're turning up with letters showing all the different agencies out there that they're linked into and establish they don't need support, that they will get those easier to comply with penalties. It is of great benefit when we're alerted as duty lawyer to any diagnosed conditions they have and any treatment regimes they're on, including if they're on a treatment authority, which is formerly the involuntary treatment orders before the Mental Health Act changes came in at the beginning of the month. Because of course that triggers Chapter 7 Part 2 suspensions and we won't be able to finalise their matters. It's also useful to know if they're on any public guardian orders or whether the public trust are involved, or whether they just have diagnosed conditions and who their treating organisation or doctor is and what medications they're on. Those sorts of things as duty lawyer take a lot of time to elicit from clients, and I'm sure you can appreciate that because you've been through it yourself, and you generally sort of start with what's your income? Oh, DSP, what are you diagnosed with? And it takes a long time. So if we have something from a referral agency saying, you know, Mr. Smith is subject to an order with the public guardian, his affairs are managed with the public trust, he's not currently on a treatment authority because he's compliant in his medication regime on schizophrenia. That sort of information has just saved the duty lawyer about 20 minutes, so that's brilliant when we get those sorts of things. If you're assisting clients to prepare any evidence they might need, it can include, you know, proof of prescriptions if they're charged with possession of a drug and they've got a script for it, or if they're saying, you know, on a possession of suspected stolen property, that was my bracelet and I've got a receipt that I can look for, or I've got some bank records to show that, you know, I paid for that item on that particular day. All of those sorts of things are great for them to come along with, even in the really early stages, because we can case conference with the prosecutor on their behalf and try and have those charges dealt with early on. Otherwise, if they can't come up with those sorts of things, they will end up going off and getting listed for trial. In terms of managing expectations of what they might, what clients might get at court, one difficulty can be if they've had advice at a CLC or from a previous lawyer, and then they come through to see the duty lawyer service and get different advice. That can be very frustrating for clients. And of course that's always going to happen. Very, very rarely will two lawyers give exact, precise penalty advice. So I'd urge that unless you have the QP9s and the criminal history coupled with a working knowledge of the current penalties that are being given for particular offences, it's better to give very limited advice on penalty. It might be, for example, that you're saying, look, I really think that you're at risk of imprisonment, but unless you're really sure that that person's going to get a 6-month wholly suspended sentence for 2 years, probably not better off not saying that particular specific advice and leaving that to the lawyer who's going to appear at their sentence. It's useful for the client to understand how long matters may be before the matter will be finalised as well. Many clients think that they can turn up and have their matter dealt with immediately, but of course they're charged with supplying a Schedule 1 dangerous drug, which is going to have to proceed on indictment. So factors for how long it's going to take them can include whether they have an election on the charge or whether it must go up. So for example, if you're seeing a client on a serious assault charge, you'd always be saying it's the prosecutor's election. You're going to have to wait until you go to court to see whether they're electing magistrates court or district court and how long that matter might take. Whether of course matters are on mandatory indictment, and then I'd always suggest to the client that it's unlikely to be dealt with in that same year. The number of charges they have, which of course determines how long their matter will take to be dealt with and whether the court will accommodate it on the first occasion. And of course whether there's dispute. If there's dispute on a magistrate's court charge, I always say to clients you're at least 3 months away from finalising the matter, and that's assuming it gets an initial mention straight to the case conferencing call over where it's listed for trial and then gets a trial date within the 7 weeks. All of those tend to blow out a little bit to make it more like the 3 to 6 month period. So that's the end of my slideshow. Is there any questions?
Terrific. Thanks, Laura. All really practical tips that will really help people in community legal centres as they're giving advice to people through this process and referring them on. A reminder to those of you participating, 2 ways that you can ask questions. Press that button that looks like a hand. We'll unmute your microphone and you'll be able to ask a question. The other way that you can get involved is to type a question into the questions box on the GoToWebinar control panel. So I might just give people a minute or two to do that.
No problem.
Laura, in terms of the documents that you suggested that people bring along, is the best way to do that really to make sure that the client is bringing them on the day, or is there any value at all in sending some of that information through before the day of hearing?
Yeah, there certainly is value in sending it through, but equally if you're sort of seeing the client and saying, oh, you know, look, there will be a duty lawyer service available on the next occasion, I'd really recommend you take in through your letter of support showing that you're linked in with Richmond Fellowship and the support they're giving you, and you might not be seeing them again. So just telling them that that's a great thing for them to get hold of and bring to court is great. But if you're seeing them at the moment they've got those documents, then certainly feel free to fax anything through to us and just say for the attention of the duty lawyer on, you know, the 20th of March, and it will get through to us. So we, whenever the faxes come through to the Brisbane office, for example, they come through to a central fax machine that's run by our listings people, and then we have a duty lawyer tray for every single court that we duty lawyer, and that will always go in there, and that's where all our memos go as well for preferred suppliers that send in memos saying we are acting and this is what we want you to get for us on that particular day, or even our in-house memos. So we have a system set up for where those faxes would go. So certainly feel free to send anything through, either indicating that you're referring them to us or that there's some information in relation to a duty lawyer client that we'll probably see that day.
Terrific. Thanks. Laura, Amber, it doesn't look like there's any questions coming through, which I think is a testament to the thoroughness of your presentation, which was, as I said, really practical and provides us in CLCs with some real concrete steps of ways that we can work more closely with Legal Aid. Can I thank both of you for your presentations this morning? Can I also thank everyone who tuned in from mainly across Queensland, but in other parts of the country too. We'll email around some resources in the next little while that might be helpful, and look forward to speaking to you all soon. Thanks everybody, and have a great day.
Thank you. Thank you.